Thank you all. Please be seated. This is a time set for oral argument in our case number CV19 0054, Brown versus Dembow. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve a portion of your time, you're free to do that. Please keep track of your own time at the podium clock. Out of respect for counsel, I would ask that those in attendance make sure their cell phones are off to avoid any interruptions and embarrassment. We have reviewed the briefs. We have conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded, so we would ask that as you begin your argument, you tell us your name and the party that you represent. With that, Mr. Abney, you may proceed.
May it please the court, my name is David Abney, here representing the appellants. I'm on day 10 of a 10-day cold, so if I cough occasionally, I'll try to cover it and not let that affect my mental processes, which, as you already are familiar, are rather slow to begin with. We had the oral argument, so I figured I would start with that. There were two questions that the court asked to address. One was whether ARS Section 13901.01, Proposition 200, applies to Paige Dembow's charges and convictions. I don't know why not. I think the statute was in place before she was convicted and committed the offense, so I assume it would apply. And number two, if so, are Paige Dembow's Proposition 200 convictions precluded from being used for impeachment purposes under Arizona Rule of Evidence 609A1? And I do not think so. The 609A1 talks about attacking character by evidence of a criminal conviction. There was a criminal conviction. 13901.01A talks about, notwithstanding any law to the contrary, any person who was convicted of the personal possession of drug paraphernalia is eligible for parole. The court shall suspend the imposition or execution of sentence and place the person on probation, and that's what happened here. The important point for 609 is not the actual sentence, but the possible sentence, not the actual punishment, but not the possible punishment, by the possible punishment, not the actual punishment. The possible punishment is what happens. And even under this liberalizing statute, 13901.01, if something goes bad on your probation on subparts E and G, if you commit a crime of certain kind, or if you commit an act in violation order of the court relating to drug treatment, your probation is over and they throw the book at you.
I think our Supreme Court has construed that statute somewhat differently in the Romley versus Martin case, where the court addressed in the criminal context, to be sure, this type of issue. So I'd be happy to have you address that case as well.
To the extent that I recall the case,
yeah.
I think the important distinguishing feature here is that you have to look under 609A1, you have to look very closely at what the possible punishment can be. And here it's possible that you can get more than a year.
Here, Martin, and I'm just going to quote, right, from paragraph 1 of that opinion, under Proposition 200, quote, a person convicted first or second time of personal possession or use of controlled substance or drug paraphernalia, and it was drug paraphernalia here, may not be sentenced to a term of imprisonment. And that's from the Supreme Court in that case. And later, at least from my reading of that case, they found that given that, and it would have been a prior iteration of 609A1, but that 609A1 for a Prop 200 conviction could not be used as a matter of right to impeach a witness.
Yes, but you can under the language, and even under, if you look at the language of the statute, if under E or G you refuse to participate in drug treatment, or if you're convicted of another drug offense, basically, then the probation goes away and you can get a sentence that's 1 year or 1.5 years or 2 years. It's possible for that to happen, and that's what matters under Rule 609A1. As long as it's possible to have that kind of a punishment, then 609A1 is triggered. It's an unusual statute. It doesn't just say felony. And
No, you mean the rule of evidence?
609A1.
Yeah, it does not mention, it mentions length of incarceration.
And the quirk there is because this came out of the federal rule, and the people coming up with the rule thought, well, there's going to be jurisdictions that define a felony as something less than a year, maybe
Sure.
maybe 6 months. And so in order to have some sort of uniformity across the nation, it came up with this year and a day, which is, has historical antecedents because the old definition of a felony was 1 year and a day. But
And
here,
in Arizona, in many respects, it works quite well. Prop 200 casts a shadow over that statement.
well, it casts a shadow. But if you look at the State versus Hatch and other cases similar to that, they talk about the possible punishment, and it's possible here for her to be punished for more than 1 year if certain things fall into play, and that's all that counts. As long as it's possible, then it counts as I'll call it a felony under Rule 609A1.
Let me ask if Martin, the Supreme Court case that I mentioned, views the law differently than what you just described, we're bound to follow Martin, correct?
If it did, but I don't think it was dealing with Rule 609A1, if I remember correctly.
Okay. I read it somewhat differently, but it is what it is.
Well, it is, and it's important to deal with the statute, but if you look at the statute, consider the rule, and then go back to the case law construing the rule specifically, talking about what is the possible punishment, then it is, here the possible punishment is 1.5, 2, 1, 0.5, or 0.33. There's a range of possible punishments for this kind of offense. And if she goes off probation for any reason, it's possible that these larger punishments, more than a year, can be imposed against her, and that's all that counts under Rule 609. There were, when I was doing the reply brief, I looked at the answering brief, and I think it was 7 different points. In the answering brief, Paige Dembow took the position that there was no conviction of a felony, which surprised me, because in the record, there's a conviction of a felony. So I went down to the court, I went to the records department to look through there and found any documents that I could find in the record of the case that said she was indeed convicted of a felony, to rebut this repeated argument in the answering brief that there was no conviction of a felony. I found 7 items, and the other side objected to 5 of those, I believe, leaving number 7 with no objection to taking judicial notice of that one, which is sort of odd because number 7 and this is in my response to the motion to strike.
Mm-hmm.
And in my reply brief, these exhibits are attached. It says the defendant was formally judged guilty of the crime of count 3, possession of drug paraphernalia, a class 6 undesignated felony. So it's right there. I don't know why they were saying their answering brief there was no felony conviction. That just baffles me. But I believe I had the right to rebut that, and I asked the court to take judicial notice of those documents. Has the court made a ruling on that, or is that being held up?
That request is pending with this panel.
Okay.
In that vein, Mr. Evans, can I ask you a question? Is at the time, so it was later designated a misdemeanor. Is that that's my understanding? Is that correct?
Yes, she completed her probation, and then the judge took it down to a felony. Pardon me, took it down to a misdemeanor, Your Honor.
At the time she testified, had it been designated a misdemeanor at that time,
Yes,
or was
I believe
that
it had.
later?
Yeah, misdemeanor, yes. Okay. But then you have to take a look at Rule 609C, which is a very unusual rule, I believe. But the court has construed it as meaning that unless that conviction has been the subject of a pardon, annulment, or certificate of rehabilitation, it's still regarded as a felony. It doesn't matter what happened to it later, unless it's one of those 3 things. And there hasn't been a pardon, hasn't been an annulment, or certificate of rehabilitation. And in fact, according to the Supreme Court, the Superior Court doesn't have the right to issue a certificate of rehabilitation. Apparently, nobody has the right to do that in Arizona. So, and that never happened.
Mr. Abney, if instead of what happened here, so we're getting to hypothetical land, at sentencing, the court said, hey, I'm going to designate this a misdemeanor. And this incident then happened 9 years later. And trial occurred 9 years and 364 days later. Your view is that conviction could be used to impeach the same witness?
As long as it is a conviction.
It
Yes.
it was a conviction, but at sentencing, it was designated a misdemeanor. There was not, there was no delay, there was no, 609C doesn't apply. But when the defendant walked out of the court at the time of sentencing, she had a misdemeanor attached to her name, not a felony. Your argument is under 609C, you still could use that as a felony.
As long as there was a conviction of a felony. That's the word that's used in 609A1, a conviction. And if there's a conviction and it is this kind of felony that's 1 year and a day, then yeah, 609 applies. You can't get around it.
Okay.
And I know this is really a one-issue case,
Right.
but it's an issue that matters incredibly.
I understand.
I mean, if anybody was on this jury, they have one eyewitness who is interested and biased. They have another eyewitness who is disinterested and not biased. And the interested, biased witness has a felony conviction. And the jurors never find out about this.
And your argument, just to clarify, because I think your reply absolutely did, there was a whisper in your opening argument of sufficiency of evidence, but that's not your argument. Your argument is 609 solely, correct?
No, that whisper died when my colleagues pointed out to
Well,
me.
I read your reply as saying the whisper, to the extent it ever existed, no longer exists.
Yeah, I would call it more of a last gasp, but it's not really the last, it's the second to last gasp.
Okay.
The last gasp for this case is 609, and it really matters because if you got this balance of the eyewitnesses, and then you have the experts coming in and saying that Ernie Markle, the other eyewitness, he didn't see what he saw. He must have blinked. One of the expert witnesses, he must have blinked or done something. He couldn't have seen what he saw. And they also say, well, she is a great witness. She's testifying absolutely consistent with our expert wisdom about this subject. And I know experts are a problem. They're a thorn in everybody's side in so many ways, both good and bad. But the one thing that the jury's always instructed of, as you know from your experience on the bench, you don't have to believe them. You can take or reject everything the witness says. It doesn't matter. It's up to you what the expert witness does and says. So here, and they rely a lot on the expert witnesses who don't even know, for instance, where the point of impact is. So it's to say that this case it doesn't matter about this problem with the eyewitness and the felony conviction. That's just blinking at reality because they can't build the case entirely on the expert witnesses, and they can't build it enough to say that they wipe out this problem. The problem is huge. It matters a great deal for any evaluation in a case like this where so much is depending on what the eyewitnesses saw.
I want to ask you, go back to the 609 issue, which I find intriguing, and that's the notion that this is, under this sentencing provision, the conviction is a felony unless it's designated otherwise. That isn't a commutation, a pardon, a certificate of rehabilitation. I mean, that's unique to Arizona law as far as I know, where you have this, it's a felony unless it's designated, and then once it's designated, it's a misdemeanor.
Right.
And so I'm not sure it really fits squarely within the rules contemplation as how we're going to treat this once it's designated misdemeanor.
Well, 609 has a bright line. It says conviction. It doesn't, and then it goes to C, okay, how do you get away? If there's a conviction and something happens to it, there's a pardon, there's an annulment, there's a commutation, there's an annulment, pardon, or a certificate of rehabilitation. Those are the three ways to get out. And simply redesignating as a misdemeanor doesn't do it. You're still convicted of the felony.
But the law's broader than 609C. I mean, you would not be arguing, for example, that if a felony conviction is reversed on appeal, which is not contemplated by 609C, but then you could use that felony conviction at trial to impeach. That's not what you're arguing.
If it's reversed on appeal, I don't think it exists anymore.
Well, I
think it vanishes.
It did exist, and I think Judge McMurdy's point is when it's designated a misdemeanor, it is not a felony. Although I'll let him speak for himself.
Well, the conviction remains. The conviction is still
But
there.
the conviction of what? That's why my point is, and it's exactly what Judge Thumb is driving at, is it's a conviction. We all admit he or she was convicted of something. But the notion is the law allows for this sliding thing. It's a felony until it's not a felony.
It's a felony until It's a felony for 609 purposes.
Well,
If
that,
it's
I really understand that's your position. I'm not sure what the statute anticipates under 603, 13603.
Well, what happens is, what matters is there a conviction under 609? If there is, under 609A, then you go to 609C. If you can't fit there, I think the felony conviction still remains as a subject of impeachment. I don't know, in your example, what the right answer is. I hate to
I
give
have
the
a
wishy-washy,
guess.
it's not
I have
this
a
case.
guess. It's just, you don't look to 609C for the answer, and that's really my broader point.
But if you completely wipe it out, I believe it's as if it did not ever exist. Maybe that's the answer for your hypothetical, which is not, as I hate to say, but I will say it, it's not this case.
It is not this case.
I hate to say that, I'm so sorry.
Well, no, you're absolutely correct.
Yeah. Well, just one more point on the reply brief. I had my colleagues, in the floweriness of their eloquence, seemed to accuse me of trying to sandbag them, blindside them, and do bad, nasty things. I had no clue that I didn't want to do that at all. I wasn't doing that at all. I simply wanted to rebut the one point that troubled me greatly when they said there was no felony conviction. The other thing is, if you take judicial notice of these exhibits, and I hope you will, because the documents are right in the record, the traditional kind of thing to take judicial notice, Exhibit 2, the first paragraph, which is initialed by Paige Dembow, informs her that the crime carries a presumptive sentence of 1 year, a minimum sentence of 0.5 years, a mitigated sentence of 0.33 years, a maximum sentence of 1.5 years, and an aggravated sentence of 2 years. She initialed that. She signed this waiver of preliminary hearing with plea agreement. So she's admitted that this kind of offense carries a possible sentence well over 1 year.
One of my recollection of one of those documents also, though, makes it very clear that this is a Prop 200 offense.
Yeah, there's citations to the statute over and over.
Well, including, I mean, there's a box that's checked
Right.
in one of the provisions, in one of those documents, which, again, we've not ruled on.
Yeah, and what matters is, once again, the possible sentence, not the actual one. Of course, it was a plea bargain. Count 3 remained, counts 1 and 2 vanished, and they're not in the record what they are, but one could assume they're not nice. Anyway, if I reserve my remaining time.
Very well.
Thank you.
Yes, thank you. Mr. Ackerman, I'm sorry, I do not, I should have looked on the next page. Ms. Briney. And I will ask if you're splitting your time or if you're carrying them.
Your Honors, I think it's going to depend on the questions that you have for me and the issues that are raised. I can keep talking, but if there's something that Mr. Ackerman needs to address.
It's your collective time, so
I
I'll
will
defer. I will want to hear from Mr. Ackerman with respect to the judicial notice request, but other than that.
Thank you, and I will make that judgment call once we get there. So my name is Kristen Briney. I represent defendant and appellee Paige Dembow. I think one of the most important things to consider in this case, and the 609 issues are important, but this case does not start and end with Rule 609. You heard Mr. Abney get up here and say that the standard that matters is the potential punishment. The potential punishment is what matters. That was never raised by the plaintiffs at the trial court. They didn't cite the specific standard. In fact, they were the ones that called it a felony over and over again. The only time they brought up whether or not they should be allowed to use Paige's, and we'll call it a conviction because 13604 contemplates a conviction, possibly a plea, and then a second conviction because it talks about a court being allowed to enter a judgment of conviction for a misdemeanor. So there is a difference. But that notwithstanding, the only argument they made that is because she had a felony at the time of the accident, they should be able to impeach her with it. They were the ones that used the standard felony. They never talked about punishment. They never.
Well, didn't they invoke 609A1?
They invoked 609A1, but they didn't cite the specific, they didn't argue specifically why. They didn't draw facts to support their analysis there. They didn't say that it was punishment. They never said that. They didn't even quote.
The reason why I struggle with your argument is that 609A1 talks about punishment. And if it wasn't punishable under 609A1, it would not be admissible under 609A1. So I get your point that they may not have used specific terms, but by citing 609A1, I'm sort of guessing you or your predecessor understood what they were looking for.
Actually,
Perhaps I'm mistaken on
no,
that.
Your Honor, that's a valid question. And the issue is we responded to, and that's why we got into the 13604 issue, we responded to them calling it a felony. And so the trial court said, I'm not going to allow you to use it because the felony is at the time she testifies, not at the time the tort occurs. The court even uses the standard of felony. They injected the improper standard, the classification.
Well, isn't that kind of a shorthand? And in Arizona, it turns out that sort of, with the exception of Prop 200, sort of neatly coincides with 609. Class 1 misdemeanor is punishable up to 365 days in jail, but not 366.
Your Honor's point is well taken. I think it's important to remember the fact that they did not argue any facts establishing, as the proponent of the evidence, that Page's conviction was for something that could be punishable by a year or, more than 1 year in prison. They didn't raise that factual issue. And that actually brings us to the 13th.
Is that a factual issue? It sounds to me like that's a legal issue. You say I was convicted of burglary. I don't need to tell the judge, oh, that burglary carries this range of sentence, or with a prior would bump it up to this range of sentence. Isn't it just a legal conclusion? It's a legal matter once you say they have a conviction for a felony, right?
Not in this case, Your Honor, because they said that there's a felony, but they didn't establish what the actual crime was. They didn't establish that that first prong of 609A1 was met. We don't know. A paraphernalia charge very well could be a misdemeanor, and actually that's what's contemplated by 13604. And Mr. Abney got up here and said that...
You lost me there. What's contemplated by 604?
So 13604 states that if there is a conviction, the court can hold the sentence open. And they can hold the offense, the designation of the offense open while the person is completing probation. And at the end of probation, if the conviction is designated as a misdemeanor, at that point it shall be considered for all purposes a misdemeanor. And that's what's being missed here, is that for all purposes, at the time that Paige Dembow testifies, and I think you brought that up, Judge McMurray, at the time she testifies, she is not capable of being sentenced to more than a year in prison.
What if instead of that she was videotaped in a deposition before the offense had been designated a misdemeanor, and that tape was played at trial?
And it was later designated a misdemeanor?
Yes. So at the time she testified, she had a felony attached to her name. At the time of trial, if she were to testify live, she would not. What happens then?
That's an interesting question, and I think that Hatch kind of deals with that. Because in Hatch, they talk about the fact that the designation had not yet occurred at the time of the person's testimony in the second unrelated case. Here, if the deposition testimony were brought up, and perhaps if there were an issue about the credibility for truthfulness with respect to the deposition testimony that was given prior to the designation as a misdemeanor, that possibly could apply. But that's not what we have here, because at the time Paige gave her deposition testimony, it was designated a misdemeanor.
And I understand, I'm offering a hypothetical.
Right.
I get that the timeline that did not occur here.
Right. I think that...
Let me ask you,
Sure.
and I'm sorry to interrupt, but from what you just said, you're not saying that to be admissible under 609A1, a felony, let's call it undesignated or designated, I don't really care, you don't have to tie it to specific testimony. You can offer it either in direct to spike your guns or on cross, because the concept is people with a felony attached to their name are less likely to be truthful. Isn't that what underlies 609A1?
That's the general concept, Your Honor. However,
Yeah, I mean, writ broadly, and that was true of the common law before the rules were promulgated in the late 70s.
Absolutely, and I think that brings up an interesting point, though, because rule of evidence states that relevant evidence can be excluded based on statute or based on the rules, and there's a conflict between Rule 609A and the way that Mr. Abney reads it, and 13604 and also 13901.01. And because there's a conflict between the statute and the rule, the statute has to apply. And the statute says for all purposes. It doesn't say that if someone has a crime that's been designated a misdemeanor later on, you can go back and dredge it up and impeach them for it. And the issue is because felonies are deemed to be relevant to materiality, and that's a serious crime that is worthy of considering whether or not someone's character for truthfulness should be considered. Prop 200 essentially says, no, these crimes aren't that serious. The paraphernalia and possession charges should not rise to that level. And that's why there's the statutory framework under 13604 to allow it, and it should be considered, a misdemeanor for all purposes after the designation.
Counsel, what if instead of being designated a misdemeanor, it was designated a felony, which is one of the two options the court could have done, or left undesignated in perpetuity? Would that change your analysis?
Yes, Your Honor, if it was designated a felony, yes.
And if, under your view, if it was designated a felony, yet for a Prop 200 offense, would it be admissible or not?
Admissible in the sense that it could satisfy the first prong of Rule 609, possibly.
Let's put it back into our case. Let's change the nature of the offense. It had been designated a felony by the time of trial as opposed to designated a misdemeanor by the time of trial. And let's set aside the undesignated aspect, the wobbly in some states is what they're called. But so it was a 6D by the time trial comes up. But it's a Prop 200 offense. Does that come in under 609A1 or not for impeachment?
It could, but in this case, it wouldn't, because one of the issues here is specific to the potential punishment Paige was subjected to as a first-time offender. The presumptive sentence for her was 1 year. The maximum sentence that could have been levied against her would require a finding of all sorts of aggravating factors that are delineated in 13, 701, and 702, and none of those issues were present at all in this case. As a first-time offender,
As part of the judgment and sentence, the original judgment and sentence, there were no aggravators.
correct, there were no aggravators. So the presumptive sentence was 1 year, and 609A1 requires more than 1 year.
Is 609A1 that granular? I mean, do you really need to go back on a 9-year, 364-day felony and say, okay, I get that the prison term was 1 year, but there were aggravators that would have subjected the defendant to something more than presumptive, and therefore it comes in? Or is it sort of the nature of the felony conviction?
I think that Your Honor is addressing essentially the 403 issue, the probative value at that point when something's that attenuated.
Well, let's set the attenuation aside. What I'm looking for, does that minimally qualify under 609A1? Because I thought I heard you say that for a designated felony here to be admissible, there would have to be at least one aggravating circumstance. And that's pretty granular. And I wonder what case supports that or what aspect of 609A1 supports that.
I think it's a plain reading of the statute, Your Honors, because in order to harmonize the two.
Well, that would be true then of every Class 6 felony, wouldn't
Right.
it? So you're saying in every Class 6 felony, when they're being offered for impeachment, that we have to go back and look to see if the trial court, when they originally entered the judgment in a sentence, even if they sentenced them to a year, post the presumptive sentence,
Yes.
that you believe that can't be used for impeachment?
Yes, Your Honor. And I think that brings up the issue of whether or not the Court of Appeals is going to do that, or the burden lies on the proponent of the evidence to do that legwork and make it so the trial court can consider all of the issues at trial. Because as you know, appellate courts are courts of review. You're not fact finders. And the way that the plaintiffs have presented this issue in this case has turned you, and requesting judicial notice, has turned you into fact finders, and that defeats the purpose. But yes, to answer your question, Judge McMurdy, yes.
Okay, I want to ask you how you review State Ex Rel. Romley versus Martin. Did you read it?
Yes, I did, Your Honor, and I believe that it is directly on point. It says that because of Prop 200, there is essentially a blanket prohibition because now Romley was later overruled in part by an amendment to 13901.01 and Prop 302. But at the time it was decided, there was a blanket prohibition on an imposition of any prison sentence for Prop 200 offenses. Now that has changed slightly, but not enough to warrant a different result in this case. So one of the other issues that has been raised is the 403 issue. And even if it was potentially reversible, or not reversible, but even if it was error to exclude it for one of the legal reasons, the practical effect is this court can and should consider looking at the evidence and upholding the trial court's decision and ultimately the verdict for any reason, even if it wasn't necessarily included by the trial court, so long as it's a correct reason. And in this case, the minimal probative value of something that happened 5 years before Page testified in this case is vastly outweighed by the risk of unfair prejudice, confusing the issues, and all the other considerations in Rule 403.
Did the trial court undertake a 403 analysis?
That's unclear, Your Honor. We did raise the 403 issue. Plaintiffs didn't have any response to the 403 issue, and as the proponents of the evidence, they had the burden to establish admissibility, which means they should have to prove that it satisfies 403, and that's not what happened in this case. But the record is unclear as to whether or not the court considered 403. And I believe I heard you say something in the prior panel. If there's confusion or uncertainty about that, a due trial shouldn't be granted. At worst, it should be a remand for clarification on that issue. So another thing that I would like to point out is the effect of Paige Dembow's credibility on what the ultimate jury verdict was. And the plaintiffs haven't established how what Paige Dembow said would have had any difference in this case. They want to say that she was biased and that her testimony mattered. Actually, if you look at the record, and I know you have done it, the experts said they didn't rely on Paige Dembow's testimony at all. You can find every single fact in this case based on either Ernie Markle's testimony or the physical evidence. The experts did not, and they made it very clear in their testimony, they did not base their decision at all on what Paige said. In fact, Detective Strohmeyer said, I didn't interview either of them, and interviewing them would have made a difference, in my opinion, that the accident was unavoidable. So if the accident was unavoidable, what does Paige Dembow's testimony have to do with there being a different outcome? The answer is it doesn't. There are a multitude of reasons, and that goes to the harmless error issue, a multitude of reasons why the verdict should stand.
Counsel, let me ask you, sort of the flip side of that is, if her testimony didn't really matter, why did you oppose the impeachment under 60981?
Because at the time, plaintiffs were calling it a felony, and that didn't comport with what the actual evidence showed. It showed that it wasn't a felony at the time that she testified. So we were focused on the felony issue. It would have been misleading to tell the jury that she is, as they said in their opening brief, a convicted felon over 24 times. They repeated convicted felon 24 times again in their reply brief. That it would have issues with 403, and we had serious problems, and we raised that at the trial court level. So, and I think this is telling, something that the, sorry, I just wanted to see if he was okay with me taking his remaining time. At one point, we brought up the harmless error issue, and the plaintiffs said, they essentially admit in their reply that the impact of her testimony has no bearing on the case. And this is what they said, kind of quoting us. Paige Dembow also argues that whether she was a felon when the accident occurred, again, that's not the correct standard, is irrelevant to whether she acted reasonably just before she killed Howard Brown, and is irrelevant to the collision's causation. But the point here is credibility, not causation and reasonableness. Well, the standard to find reversible error is that here it is. Exclusion of admissible evidence is not reversible error if the verdict would have been warranted, and the facts as we laid out establish that it would have been warranted, even if the evidence had been admitted, and its admission probably would not have changed the result. Well, if it doesn't go to negligence or causation, how would it have changed the result? The answer is it wouldn't have.
Counsel, before your time expires, what's your position on the request for a judicial notice?
Your Honors, we would request that that be denied. A major issue in this case has been waiver and also invited error. They claim that they were hampered and hamstrung from impeaching Page's testimony that they elicited. They got the ruling. They knew that they weren't going to be able to ask her or impeach whatever she had to say with this prior conviction, yet they asked her about her braking, her swerving, her driving skills. They asked her if she was a perfect driver, and now they say they were prejudiced because they couldn't impeach the very testimony that they elicited. So the invited error is an issue, but also waiver. And as your Honors know, the issues that they brought up in the documents that they set forth in their reply brief, those were not at all a part of the record on appeal. And if this court is going to be a court of reviewing and not fact-finding, it needs to uphold the long-held standards of...
But I thought there was a long-held standard that we can review the Superior Court records. I mean, there's not really a dispute on these records, is there?
You can, Your Honor, you can review the Superior Court records, but there's a specific case, and I forget, I don't have the site, but it's that you can review the Superior Court records in that case that was on appeal. This is a separate Superior Court case matter.
The case says we can review whatever the Superior Court could review. And as a Superior Court judge, I used to review records within the Superior Court all the time.
That is true. It is your prerogative, but with long-held standards of waiver, we would request that you don't. And the interesting issue is we argued that there was a lack of judgment of conviction at the trial court level, not once at trial, because these were publicly available. Mr. Abney did it after the appeal.
The judgment of conviction when? I'm sorry, I'm missing this.
In IOR 276, in our response to their motion to use Paige Dembow's conviction, we said, no, there's no judgment of conviction, and we attached 2 of the exhibits, and they knew at that point...
When it had been designated a misdemeanor.
Correct. They knew at that point they could have gone in and gotten the records and filed an offer of proof. They could have filed a reply to their motion. They could have filed a memorandum, a motion for reconsideration. They didn't do any of that. They've waived those issues, and we think that that's a reason why the court should deny their request for judicial notice.
And counsel, I appreciate that. One follow-up, and then I'll look to your colleague and give you, before that, a sentence or two to sum up. But do you challenge the accuracy of any of the documents for which judicial notice is being sought?
I can't say one way or the other, Your Honors. We didn't have a chance to review the entire record, and it would have been nice if the trial court...
When did you get the reply brief?
Sorry, the entire record of the criminal court case. We only have what Mr. Abney pulled.
Right, and my question is, do you challenge the accuracy or foundation for any of those? I get your objections on waiver and other things. My question is a somewhat different one.
I don't have a basis for challenging it, but we do challenge what those documents mean.
Of all the things I understand today, I understand you're not conceding that we should grant that. I get that,
Okay.
that you're opposing that. Now, let me give you a 30 seconds or so to wrap up, and then I want to hear from Mr. Ackerman, then Mr. Abney last.
Yes, Your Honors. I know we talked a lot about Rule 609. That is not the sine qua non of whether or not there should be a new trial allowed in this case. There are at least 6 reasons, any one of which are fatal to plaintiff's appeal. They waived the issues. The court did not err because they ruled correctly on the timing issue as to what counts as a prior conviction under 609. They lose under Rule 403 considerations. They lose because they invited the error that they now complain of. And also there's harmless error, and that's notwithstanding the jurisdictional issue. So if Your Honors believe in any one of those, they should not be allowed to have a new trial, and the jury verdict should be affirmed. Thank you, Your Honor.
Thank you. Mr. Ackerman, my question for you is on the judicial notice request and whether your position on behalf of your client differs from Ms. Briney's in any respect.
It does not, Your Honor. The only thing I would add is We were not given the opportunity, because it was not raised at the trial court level, these particular documents, to introduce any of our own. And again, we haven't had the full scope of the criminal record. At least we don't know for sure what's been introduced and asked to be taken judicial notice of is the full scope of the criminal record.
I'm almost positive it's not, but just having
So
some
that,
knowledge
so I
of
join
how-
in hers.
Very well.
In her.
But with respect to foundational question, you have no basis to
I have no
challenge
basis to
Very
challenge
well.
that. I would just add one point, unless the court has any questions on the family purpose doctrine, I rest on our briefs.
Very well. Thank you. Thank you. Mr. Abney, rebuttal.
To get about an hour of rebuttal, but nobody invited error. They did the best they could down below to make sure there wasn't an error. And as far as Rule 403 and all that related paraphernalia, at the trial court, and it's in the transcript of Trial Day 1, which I quote in the reply brief on page 15, Trial Day 1, page 13, lines 10 to 17, this is what the Browns lawyer said. She complied with whatever they want to tell the jury, that it was reduced to a misdemeanor. But for Rule 609 purposes, it is treated as a felony. And that's the important point. It's treated as a felony. The trial court, however, said, well, it's a misdemeanor now. It's been redesignated, and that's the end of the discussion. Period. And that's the basis of the ruling. 403 didn't come into it. If it did come into it, which they sort of hid in their answering brief, in the reply brief, I went through the various factors of why Rule 403 would not preclude this kind of evidence. There was no invited error. As far as the items, I copied the items at the record place down on Jackson Street, the full item, whatever the item is, I copied it in full and put it in there. There were other things in the record, not a lot, actually. It was a very sparse record. I didn't even see a pre-sentence report. I think it was waived or something happened with that. But they could go down there. They got paralegals and clerks. I don't have any of that sort of stuff. I went down there personally and looked at it. It's right there. You go through all the records you want to go through. I don't know why they say they can't do it. Geez, I did it. The conviction was in 2015. The trial was in 2018. I heard something saying, this was 5 years old. Well, the conviction was 3 years earlier. The important point in Rule 609 is it talking about the conviction. And it's very clear. It talks about the criminal conviction, and there was a criminal conviction for the felony. As far as the aggravators, there's no discussion of aggravators at the trial court, the criminal court, for a good reason. It's a plea bargain. Why would you bother going into aggravators on a plea bargain? There was certainly a possibility with this kind of criminal offense that you could get a bigger sentence. In fact, she acknowledged it herself, the initial paragraph warning her about the various kinds of possible sentences, and the possible sentence is really what matters. I don't know how you can come into court now when you sign one of those things and initially talk about possible sentences and say, no, that's not a possible sentence. I think there's a little bit of, talking about it both sides of the mouth at the same time on that problem. There is that sentence in my brief is about, we're not talking about causation and whatnot, and we're not. We're talking about credibility. We're not trying to use, at this point in the brief, trying to say because she is incredible, there's no causation. That's going to be for the jury to figure out. And that's what that sentence was. I thought it was a pretty good sentence when I wrote it, but I guess it wasn't, because it confused them, and the last thing I want to do is confuse anybody with what I write. The point is credibility and having a jury there with these two eyewitnesses and dealing with the credibility. And then the last point is, penultimate point, I suppose, is their accident reconstruction biomechanical expert, Michel Puzel, emphasized to the jury that it's Page's ability to recount what happened that, quote, is the difference. All right, end quote. So they're experts, and that's just an example of their experts relying on what she said and attacking what the other eyewitness said, Ernie Markle said. And I've run out of time on the dot. Thank you very much for your time and attention. I appreciate it.
Thank you, Counsel. We appreciate your briefing. We appreciate your presentation today. You've given us much to think about. We will take the matter under advisement. We'll issue a written ruling in due course. Court stands adjourned.